Number 65, matter of Natasha W. versus New York State Office of Children and Family Services. Counsel?
May it please the Court, Matthew Grieco for OCFS. May I reserve 2 minutes for rebuttal, please?
Yes, sir.
OCFS was permitted to uphold an indicated report of maltreatment based on the undisputed facts of this case. The following relevant considerations supported OCFS's determination: the child's active involvement in a crime at his parents' direction, the age of the child, the substantial amount of goods stolen, which increased the likelihood of a physical confrontation.
So there wasn't any evidence, right? This is all speculative. There wasn't evidence of an actual impact on the child, correct?
We are not relying on actual harm as a basis for the maltreatment finding. In every stage of this proceeding, from the ALJ's determination up through this court, it has always been the position of the agency that maltreatment occurred because the child was placed in imminent danger of harm.
But isn't that based on speculation?
It is not. There is an inherent danger in any physical confrontation, and under the particular circumstances of this case, given another consideration which I was about to mention, which was the substantial amount of goods stolen, as well as the lack of mitigating circumstances.
I think we're familiar with the facts. How do you interpret imminent?
Imminent means that it was it was reasonably foreseeable that it would immediately follow from the petitioner's actions. For example, in New York, there is a shopkeeper's statute that permits some degree of force to be used in a physical confrontation when someone is attempting to rob from a store. Now, the substantial body of case law that has arisen under that statute, for example, demonstrates—
You're answering a different question, I think, which is that there was, at the time of the arrest, there was a chance of some imminent risk. But isn't the statute asking about the imminent danger of the child being impaired now? That is when OCFS is making its investigation?
No, and that actually brings me to a point that is raised in both the petitioner's papers and in the amici's papers. Although the maltreatment standard and the although the maltreatment standard is defined by reference to the neglect standard, those two standards arise in proceedings that are asking two fundamentally different questions. When OCFS is reviewing a request to amend an indicated report of maltreatment to unfounded under Social Services Law 422, that's this case, the question is whether the child was placed in imminent danger by unreasonable parental behavior on a specific occasion. In a neglect proceeding under Family Court Act Article 10, the question is whether the child is currently in imminent danger.
Well, isn't the argument there that maltreatment and neglect will amount to the same thing?
The standard that is used to evaluate whether the harm was imminent and what degree of harm is required is the same harm. But the question being asked in the proceedings is, in a maltreatment review, whether the child was at a specific moment placed in imminent danger.
This case seems to me to be about the standard. And so what about a V&T violation? Driving drunk with my child in the car.
Would that be maltreatment? Is that the question? Driving drunk with a child in the car would under most circumstances that I can imagine, be maltreatment.
Speeding?
If the speed is high enough. It's always going to be a totality of the circumstances.
How about running a stop sign?
If it was under particular circumstances, it might be. There's no categorical case, but running a stop sign could if the parent.
So any negligent. I'm sorry.
No, please.
Any negligent act by a parent can be translated into maltreatment.
It depends on the totality of the circumstances. There's many kinds of acts that would qualify as a poor judgment.
Does it matter? We have case law that talks about child using a bank robbery. And that's, of course, a felony charge.
Right.
And here we have a child that was, the way I understand the allegations, used in a misdemeanor, a petty larceny.
Right, and the difference...
Does that distinction matter between felony and a misdemeanor?
It matters as one of the circumstances that affects whether there is a determination of maltreatment or abuse and whether the determination is maltreatment or abuse. The Richard case, for example, was an abuse case, which requires a finding that the child was at danger either of death or of the loss of an organ, so an extremely serious degree of bodily harm. And yet, in that particular case, that appellate division found it satisfied, although there was no confrontation.
It's just sending a message to the child? Or even expressly saying to the child that shoplifting is okay would not constitute maltreatment?
What you're addressing now the danger of mental or emotional harm, and that is a separate basis on which the determination of maltreatment could be upheld in this particular case. This court should reverse if it finds either physical or emotional satisfied.
What if I'm a parent, I'm with my child in the store, the child takes a candy bar, and I see the child wants this candy bar, I don't want to pay for it for whatever reason, I say, well, just put it in your pocket. Maltreatment?
I don't know that that's going to be maltreatment in every circumstance. If it is the kind of thing that, if there are exacerbating circumstances, might be maltreatment, at least as to the physical confrontation.
Well, so how is that different between put on those boots and put on the coat?
Well, the substantial amount of merchandise that was being stolen in this case, which, as the ALJ and the Disempolo both noted, came close to $3,000. That was one factor that the OCFS reasonably
So the factor
considered.
is really that the child was being used in an organized shoplifting effort rather than...
That is correct. The child was not merely was not merely present.
I kind of agree with that. The problem I'm struggling with is a 5-year-old being used. 5-year-old, really? A 5-year-old can draw that kind of distinction. Now, if I was 12, I could see that. But, you know, these rational distinctions are the basis of the law and the application of these standards. So I'm wondering, would it be a different standard or a different application if the child were older as opposed to the child being younger?
The age of the child would always be a consideration. Here, I don't think OCFS acted unreasonably, including that 5 is an impressionable age.
So if it was an infant, for example, who had, in this same situation, an infant, and mother puts diapers in the infant's stroller and uses the infant to commit a crime, okay? Is that a same case as we have here, or different?
Well, at least with respect to that case, if it's an infant, the child's not going to understand what's going on, and the danger of mental and emotional harm is
So
reduced.
you're not asking for a bright line rule?
We are not. We are emphatically asking for the court to hold only that that OCFS was permitted to reach the determination that it reached, not that determination.
What's our standard of review here?
The standard of review is whether the evidence of the trial was legally sufficient to permit OCFS to reasonably conclude that maltreatment
It's
occurred.
not in Article 78 where we're looking at whether it's arbitrary and capricious or irrational?
Yes, the question that she has explicitly raised in her petition is that the ALJ's decision was affected by an error of law, and our position is simply that the decision was not legally erroneous. I want to quickly...
Counsel, do you care to turn to the R&R findings?
Yes, that's exactly. So I want to turn to a problem with how the First Department framed this case. The court below said that the issue is solely whether the petitioner's name should be maintained on a list that would make it difficult for her to obtain a position in childcare. But that is wrong, because someone who provides evidence of mitigation or evidence that her conduct will not recur could avoid an R&R finding even for the exact same conduct that the petitioner acknowledges she engaged in here. And if there's no R&R finding, the existence of the report cannot be disclosed to employers, even though it was upheld as indicated.
So
and
just
that
to
is the
be
point.
clear, what are the categories of mitigation evidence you're thinking of? What if she came forward and said she was doing something to ensure she never did this again?
Right. That is correct. The ALJs in these proceedings are accustomed to seeing affirmative evidence of mitigation, such as testimony that they have not, that it's not going to occur, how people have taken parenting classes, that kind of thing, and
In
testified
her
to
case,
that.
because she has no record, I assume your position is that might have been a viable argument on her part?
If it is the case that her conduct is not at risk of recurring and had not occurred and had not reoccurred by the time of the ALJ's hearing, an appropriate thing that an ALJ would expect someone to say would be, this hasn't recurred, and
she didn't testify, right?
and she was counseled at the fair hearing and made a decision not to testify. And as this court said in the Denise J. case and other cases, the ALJs are permitted to draw a strong negative inference when someone is engaged in such conduct and chooses not to explain it. And
Thank you,
May
counsel.
I, Chief? May I?
Yes, of course.
I'm sorry. I'm a little confused, and it may be me, of your approach, because on the one hand, you seem to be saying that it's an objective analysis. So if we look and we see, there's no impact on this particular child, but look at these circumstances because this child was used in this shoplifting incident. But then when you were asked about an infant, and you said, well, that could have no effect on the infant, but why wouldn't the objective considerations be the same?
So the objective prong of the maltreatment analysis comes in one of the two prongs. The objective prong is whether the parent's act was objectively unreasonable under the circumstances. We understand that prong to be conceded before this court because we raised it in our opening brief, and the respondent chose not to dispute it. The question of imminent harm, that's always going to be or imminent danger, is always going to be a totality of the circumstances analysis.
Right, but, okay, so isn't there some need in that second prong, if the first part is an objective analysis under your standard, for there to be some impact demonstrated on the particular child? Because
that would
why
be
isn't it then
inconsistent.
just the first prong again?
Well, that would be inconsistent with the statute, which allows a finding of maltreatment based on either actual harm or imminent danger of harm. And on the particular facts of this case that I enumerated at the start of my argument, OCFS reviewed the considerations that are relevant to determining whether the danger was imminent as opposed to merely possible. With the court's permission, I'll reserve the balance of my time.
Thank you, counsel. Counsel?
May it please the court, Audra Soloway from Paul Weiss, Rifkin, Wharton, and Garrison LLP on behalf of respondent Natasha W. Before I jump into what the state just covered, I want to pause for a moment on the jurisdictional question because we believe that there is no jurisdiction for this court to hear this appeal. As the court is no doubt aware, the sole basis for this appeal is under CPLR 5601A, which provides that an appeal may be taken as of right only where the dissent.
Let me ask this, what facts would you say are in dispute?
So I would say that the record, while it's closed and before this court, is the record. The inferences to be drawn from the various facts and the way that the judge in the dissent looked at the facts differently and applied the law to the facts does not create a question of law as the statute requires.
I thought in an Article 78 proceeding, where it's always a question of law as to whether it was arbitrary and capricious, irrational, or an error of law. Why is this different?
It's different for a couple of reasons, and I think the most important one is that when you decide whether 5601A has been satisfied, the only thing you look at is the dissent below and the basis for the dissent below. And here, what the dissent was based on, the two-judge dissent, was based on that judge's inferences and the way that judge felt that the facts were.
Or was it based on whether the minimum standard for making these findings was met? Well, then even if we are looking at whether it's a mixed question, it can be a question of law.
Right. I mean, if you look at some of the findings by the dissent here, just to give you an example, what the dissent said is, I would find that petitioner's utilization of her 5-year-old son to steal 2 coats and a pair of boots from Bloomingdale's constituted maltreatment and was sufficiently egregious so as to create an imminent risk of physical, mental, and emotional harm. So what the dissent is saying is the inferences that I would draw from this behavior, my understanding of the facts here, it does meet the legal.
Or it could be that, right, or that under no circumstances does this meet the, Nicholson standard or whatever.
But I think what's important is that the dissent relied on the exact same statutes, the dissent relied on the exact same Nicholson standard. There is no dispute about what the relevant legal standards are here. The dissent just drew different inferences.
More of a legal sufficiency question.
Which I think.
Are these facts sufficient to meet the standard? And that seems like a legal question.
A mixed question of fact and law under this court's.
I'm not sure I agree with that.
Your
So
Honor, I think.
on the merits?
Yes.
Isn't the logical result of what I thought was the rule you were promoting in your briefing that they would always have to present expert testimony of the impact of an involvement in criminal behavior would have on the child?
It is not our argument that the state would always have to present expert testimony, and you could think hypothetically in this case of several ways that the state might have been able to prove its case. We're not arguing that there's no case of shoplifting where the state could meet the burden that it has to meet. You could imagine, and we don't know what would be in the record here because the state didn't put it in, but for example, you could imagine a situation where when the caseworker interviewed the security guard at Bloomingdale's, the security guard may have been asked, how often does a detention at Bloomingdale's or at a department store, in your experience, result in a violent altercation or a physical altercation? Or when they interviewed.
Well, what if the kid just started crying when the mother gets arrested and he sees mom leaving and put in the cage that they have at the department stores waiting for the police department. Is that a sufficient impact?
I think if the child were sufficiently distressed that, that you were able to, using some kind of, perhaps the social worker at the school, for example, could have given an opinion on whether that kind of distress has presented an imminent risk of harm to the child, that might be one piece of evidence that in the totality of the circumstances could perhaps, start to push this across the line. But I think the important...
Seems to me, though, that in the examples given, in that one, it's was the child actually harmed, okay? And in the other one, we're talking about imminent physical harm. I think the harder one to get at here is the imminent emotional harm. And so, I'm interested in how one would prove that, in your view, short of expert testimony.
Right. Well, to be clear, at the hearing, hearsay is permitted. So an interview with a psychologist, an interview with a school social worker, all of that could come in. So I think
That's like expert testimony, so.
well,
right?
these interviews were conducted anyway, and had these questions been asked, we don't know what the answers might have been. I think the point I'm trying to make is it wouldn't have been necessary for the state to go out and retain an expert to bring that person in to testify. It's a far lower threshold because hearsay is permitted.
Doesn't that end up being the battle of experts? And so in one case where the exact same conduct occurs, you're going to have a battle of experts, and that comes out one way, in another case, same conduct, it comes out another way?
Well, I think the bottom line is there has to be some evidence, and it may be expert or it may be fact evidence, from which you can conclude that there's been an impairment of mental or emotional condition. And that impairment has to be near or impending. It has to be imminent. It can't just be merely possible.
What if the grandparents had instead told the investigator, oh, she does this all the time?
Well,
Would that change things?
I think you would still need some evidence to understand whether, when you expose a child to repeated instances of shoplifting, that has some, impact on their mental or emotional
Aren't we
condition.
back to you need an
But I
expert?
think that's a very different case, because here, the proposition that the state advanced was that a single isolated instance of shoplifting is enough to push us from merely possible to, imminent, near, impending.
But it still comes down to the standard, which is whether or not there was a failure here to exercise a minimum degree of care, right?
Well, I think the standard here is whether...
Or a maltreated child.
Well, the standard here that we've contested is whether an imminent risk of danger has been proven, either physically or
Okay, so Nicholson then, yeah. Okay.
emotional.
Counsel, does the fact that the agency didn't initiate a neglect proceeding in family court, or there were no services that were ordered for the mom, does that undermine their finding?
I don't think, and I know this came up in the briefs because there was an assumption that that was the conclusion that the First Department here reached. The First Department looked at all of the evidence, including whether whether services had been recommended or whether there was a risk in the home of any kind. But that's really just taking the totality of the circumstances and considering it, which is precisely the inquiry that Nicholson suggests. The mere fact that they didn't take any action outside of putting our client on the registry, that in and of itself, I think, doesn't have legal significance.
One of the cases in the spectrum of these kind of cases is Rashad D., which is the bank case. You're familiar with
Yes.
that. And, of course, there, I think you could argue that during the act of robbery, that the child was in imminent physical danger. It's a little bit different here. But it's still on that same continuum, and we're talking about a misdemeanor crime, petty larceny, versus a felony crime, and it seems that if it meets the elements of those crimes, how is that not a danger to the child's future mental or emotional well-being?
Well, I think that the danger here of relying on...
I'm sorry, I phrased it a little poorly. How is it irrational, I guess, to make that conclusion?
Well, as Your Honor pointed out, the Richard D. case is a very, very different case where a 12-year-old was instructed to walk into a bank with a note threatening violence, and there was evidence that the police would come in
I think you're
with
right
guns
about
drawn.
that.
Hasn't
Right.
maltreatment been found in cases where there's just sort of a failure to supervise and a child wanders off and no actual harm occurs, but there's, and as far as I know, no expert testimony. So to me, that seems to be sort of on the other end of the spectrum from the armed robbery, and this is somewhere in the middle. So Why doesn't this fall?
Well, I think that what's hard about this area of the law is this court has expressly said, and it's done that in several other decisions, that there's no bright line rule here. It's every case is taken on a case-by-case basis where you look at the specific circumstances.
But if
That's
just
what
losing track of your child for a few minutes can lead to a finding of maltreatment, I don't understand why this can't rationally be found to constitute maltreatment.
I don't think losing track of your child for a few minutes without extenuating circumstances, and obviously it would depend on the child's age and the situation and the place that you were located in, but I don't think there are many, if any, cases that have held that merely doing that is maltreatment of a child. But I think that this case would be the first case that, and there's no cases cited in any of the briefs where an isolated instance of petty larceny or petty crime
But
was.
it's not just the petty larceny. If she went in with this child and surreptitiously, took a few things and put it under a coat, didn't involve the child at all, we might very well be looking at a completely different case.
But that assumes that this 5-year-old, based on an isolated instance where he was used to shoplift with his mother, appreciated what was going on and learned
How do
from
we
it.
know it's an
And
isolated incident?
Well, there is no evidence in the record. There was no
that's right.
criminal history, no prior ACS history. All 4 grown-ups who lived in the home, her sisters and her parents, both said that they were aware of no other instance of
Maybe
this.
he was so calm because this had been done several times before and it was no big deal. And they never got caught. That's a possibility, isn't it?
Well, Your Honor, I would respectfully submit that does not get us to near an impending. I mean, I think that's the land of, we're sort of speculating.
But your position is absolutely no consequence. But the child has no consequence, having not only observed their mother commit a crime, get arrested, but having been an absolutely integral part of the attempted crime.
I think the problem is that there's no evidence in the record from which we can conclude that there was a consequence. He wasn't upset. His school social worker said he's doing beautifully at school. The grandparents and the aunts all concurred that he has
That's
a
what I'm
happy,
saying.
healthy
We are now
home life.
back to the logical end result of your argument is that they've always got to have expert testimony. But there's no way around that.
I don't think they needed an expert here. If they'd asked even just the school social worker, what's your view when a 5-year-old is used by his mother to shoplift?
And then you'd be
Does that-
saying, what does a social worker know?
Well, then but then at least the state would have put in some evidence that an isolated instance of shoplifting gets them from merely possible across the line to
How
impending.
about some evidence, not along this vein, but a different line of the child when asked, has this happened before, saying yes and then no? How about that, as showing recurring conduct?
Right. I think he said yes, then no. None of us obviously were there. That's in the cold record. I think the fact that 4 grown-ups who live in the home all said that they weren't aware of any instance of it, the fact that there's no
They're all
criminal
related
history.
to her, they all have a connection, you see the point there.
The
right?
fact that there's no criminal history or prior ACS history, I think that you're allowed to draw, we can draw inferences from the fact that she didn't testify, but they have to be reasonably based on the record. And to conclude that this had happened on numerous other occasions goes beyond what the record here can support.
Thank you, Ms. Sullivan.
Thank you, Your Honor.
Counsel?
My counterparts focus on on how the child is doing at home, and the broader investigation illustrates how this case is fundamentally about what role we're going to expect the SCR to play in New York, the statewide central register. As a matter of long-standing practice, as demonstrated by its own past practices and the CPS manual that OCFS distributes to CPS workers throughout the state, and a substantial body of case law, the SCR has always been understood as a record of specific acts of maltreatment or abuse. And by contrast, the position of my adversary and her amici would result in a world in which an entry in the SCR is only appropriate when there's a determination of current dangerousness to the child or actual harm as opposed to imminent danger. That would defeat the purpose of the SCR, which is to serve as a record of specific past acts in which a child was placed in imminent danger by unreasonable parental behavior in order to track caregiver whose past behavior raises red flags that are useful in at least 3 instances: in future investigations involving the same child or the same caregiver, in instances where a caregiver may be placed in charge of the children of others, and for statistical purposes. purpose. And turning back briefly to the R&R determination, that is the point in the analysis at which it is appropriate to consider the potential effect on the petitioner, not the earlier determination of whether there was maltreatment. That is an important error in the First Department's decision that I wanted to highlight, that its focus on the effect on the petitioner is misplaced to the extent that concern is considered during the evaluation of the maltreatment issue. That comes into play as one of a number of factors in the R&R determination. And with respect to the R&R determination, we think it's extremely important, however, that this court clarify the very deep and broad error in the First Department's determination on that issue. It essentially adopted a presumption of irregularity in administrative proceedings unless every guideline is discussed by name. The SCR, of course, in its initial determination on page 177 of the record, listed several factors that it took into account at its written review. That was then before the ALJ, who referenced his earlier discussion and then addressed the additional factor of the petitioner's failure to
Your
demonstrate.
position is if one could comb through the opinion and identify, without the express terminology in the opinion, that I'm now addressing this factor, and now I'm addressing this factor, but if you could comb through and say, well, that goes to that factor, that addresses that factor, as long as those factors are relevant, the ALJ has done their job.
Yeah. I don't think it takes a great deal of combing in this case, Judge Rivera, because he had made it very clear just a page earlier the degree of seriousness that he attached to the act and his concern about the effect on the child, both of which are factors. And then that, plus the fact that the SCR itself had already enumerated several factors, and his statement, as discussed above, where he incorporated his earlier decision by reference, that is, under any reasonable standard of deference to administrative agency and administrative procedure, correct.
That's what I'm saying. You're looking back for the context of the opinion to determine that, yes, one could look at this and say that the factors were taken into consideration, even if they're not enumerated specifically.
That's right. In most cases, if someone were challenging an R&R determination, it would ordinarily be brought as a substantial evidence challenge. She specifically did not bring in a substantial evidence challenge here. So the R&R determination should only be set aside if she meets the very high bar of showing that it was procedurally irregular, which she has not done.
Thank you, counsel.